Welcome to Stolen, the world's greatest eminent domain podcast. Legally, the government has the power to take your property, but most people don't know what to do when it actually happens. If you don't respond correctly, you could walk away with far less than you're owed. And when that happens, in effect, the government steals your property. Our mission is simple: protect property owners, make sure they get the compensation they deserve. The government will steal your property, but only if you let them. Hey, I'm Chad Brown. I'm your host of the Stolen podcast, where we talk about all things eminent domain and land condemnation. Here with my co-host, Caleb Wheeler.
Hey, Chad, how are you?
I'm doing great, man. How are you?
Good.
Caleb runs the eminent domain land condemnation practice group here at Chad Brown Law and is the go-to guy for all of our clients for eminent domain cases. So today, what we're going to do is we're going to stay in this sort of 10,000-foot view, and we're going to roll through and look at the eminent domain process in pre-litigation. Now, I'll talk about what that means in a minute, but basically, we're going to look at the process up through what would be a condemnation action, an actual taking. That's once you get into a taking, the whole thing just changes. And there's so many different things that go into when you're in litigation. We spend a lot of our time working with people in this pre-litigation division, part of the process. So we're gonna really dive into that today. So is it correct that people should be thinking about eminent domain? Really, there's a pre-litigation phase and there's a litigation phase. Is that right? I mean, and not in every case, but they're very distinct parts of the process. Is that right?
Yes, sir. Generally, Chad, I would advise people to think of it in that way, especially when I'm talking to other attorneys or whatever. Generally, we do think of it in that way. It's a pre-litigation phase, whereas we are negotiating a settlement, we're negotiating prices and terms like that. And then litigation, we're not able to come to terms with the state or whatever condemning authority there is. And as a result of that, they're forced essentially to file condemnation against the landowner to force the taking. So with that being said, that's kind of the two stages I generally tell people to think about it. And there's certain instances as well with specific types of property and different scenarios where we're planning for litigation, even at the very outset. So we know it's going to go to litigation regardless of what happens.
Right.
So that just depends on it's a case-by-case scenario or call. But generally, yes, Jed, I usually do say, hey, it's pre-lit or lit. We think of it those two umbrella terms.
Right. So because one of the things that happens is you in just a typical sort of residential and commercial cases can be different. There's a lot of different issues with commercial cases. Commercial just being where someone's business is being affected rather than just their personal residence or their personal property. But in a typical residential taking or eminent domain case, pre-lit, you're going to deal with a different range of people often than you're going to deal with litigation. Once you get to litigation, you have typically the Attorney General's office involved or some local counsels involved. With the litigation component had to start with the filing of legal action, so necessarily there's lawyers involved. In the pre-lit, sometimes there's lawyers involved, sometimes there's not. And so I think one of the big distinctions people need to understand is that what's happening is in many respects the same, but who you're going to deal with and the people you're going to interact with in the pre-lit are going to be different than litigation.
That's right. That's right, Jeff.
Okay, so one of the things we have to think about, though, is sort of where does it actually start?
Right.
Like, what is the starting point of an eminent domain action? So where would you say the process?
Right, yeah, it starts with the legislature, most commonly with General Assembly, which is the elected body politic, where decisions or appropriations of funds are made to do government-sanctioned projects. County commissioners' meetings as well, another good place for them to start. Town meetings, town halls, things like that, depending on where you are in the country and how the municipality government is set up. That's generally, though, where these projects, these inclinations of infrastructure development will begin.
Right. So one of the things that I think our clients they're concerned about initially when they come to us is that they've told me they're going to take my property. Can I stop them? But I think it's fair to say that usually they're way farther into the process than they realize in terms of if you look and just sort of step back and look at the entire eminent domain process. I think if you go back and understand what eminent domain is and where the right comes from, and we get back to this idea of public use, it's fair to say the process starts when there becomes a awareness of a public need by an entity that has eminent domain authority.
Right. And so with that being said, when it comes to this awareness, that's where we start getting calls sometimes. People come up to me who are not looking for representation, but they somehow figured out or learned that I'm an eminent domain attorney, and they start peppering me with questions about things and putting it on my radar, which I'm thankful for. I'm thankful for that. Because sometimes things do slip through everybody's grasp, right? There's just so many projects going on at any given time in these states that we're working in, and also other states in the South, and states out West, like Colorado, and Hawaii, which is a whole other podcast in itself. Trust me. Hawaii is a unique issue, but
fan of politics. Can we talk about, I just want to talk about the process for residential stakings for eminent domain.
Right. Yeah. So yeah, no, that's generally what, the awareness of when we start getting those calls.
Yeah. And I think it's important though, because people understand one of the questions that we frequently get is there anything I can do to stop it? And typically when they're asking the question, the answer is no. It's very difficult to prove there's not a public use of a project that's already been approved and already be funded. One of the things that people need to understand though, is you do have the opportunity to actually stop an eminent domain project. You stop it by lobbying your legislator, lobbying, being involved in local politics, being involved at state level politics when this need arises. Because what usually is happening is you have local congressmen or congresswomen who are working, understanding their constituents' needs. They're raising this issue. And so what we encourage people is there is a time in the process where you can have a much bigger voice in whether that project proposal is going to affect your property, but it's usually not when you're calling us because you got to notice that they're taking your property. It's really something that people need to understand is that if you want to, if there's a threat that your property is ultimately going to be taken, the time to engage and try to stop that is not after the fact, after the legislature has decided to pursue the project that's going to lead to you losing your property. It's being proactive, being an advocate for your property rights in the beginning part of the process, not when they come to us.
And I'll chime in here and I'll say this. In my opinion, I would argue that you have more of a chance to fight it on a local government level. You'll see these signs, people will see these signs staked out in certain pieces of land, says public hearing to be held on such and such date, for the commissioners meeting, or would it be a municipality meeting? In my opinion, you're going to have more chance of fighting in that specific circumstance rather than, let's say, a state funded road widening project.
But the reality though is in almost all the situations there is an opportunity to be heard, either directly or through your representative. But the reality is most people see that sign for public hearing, or they see that notice in the newspaper. How in the world are people supposed? I said, they're not supposed to know the notice. It's in the newspaper, for goodness sakes.
Right.
I mean, they should probably have to put all news notices on TikTok.
Yeah,
that would be no one asked me. There's a whole list of stuff. No, man, if I had $1 for everything nobody asked me about what we should do. All right. Anyway, the point is that there is time to participate, but it's not when they get to us. But let's get past that. Okay. So there was a public need. It was determined that there was a public need. They decided, let's just use road widening. Those are the projects that we're seeing the most in a residential context. We've got a road widening project. So the legislature votes and says, we're going to widen the road. And so like the next day they come down and they talk to you about it, right?
Yeah. No. Yeah. So they vote that we're going to, essentially they decide they're going to do the project, and then it goes to basically a study. It goes to a study phase. Surveyors. We have surveyors going out surveying the land to be taken, and then we also see a lot of engineers getting involved. And so the state will hire engineers of various flavors to get involved with the construction process, how they're going to construct it, what they're going to construct, where they're going to construct it, what should be constructed in conjunction with the road. So yeah, that's when all of that starts to begin.
And then they have to fund it, right?
Then it has to be funded, and that has to be done by the legislature, because general rule is all funding has to be initiated with the General Assembly.
So the reality, though, is what people need to understand is that there is this sort of public need that comes up. The legislature or the local government will make a decision. The local government might be acting more quickly.
Sure.
And then I know we had a meeting with a client last week, and they were talking about this long history of this project, and one of the things that someone had told them was, well, it's never going to happen. Like, they had this idea, I guess that they actually weren't going to take the property,
right?
Which I mean, they're speaking. They knew it was going to happen, but the point is that from the time that the group that has the legislature or local government or utility, whoever it is, there's usually going to be a somewhat significant window between the decision to actually take land and the actual implementation of that, such that they're going through the process. So I think you understand, you're going to have this public type hearing about the project. There'll be a legislative decision in some capacity, or the legislature will work in conjunction with the utility or whatever it is. And then a lot of times it's just you wait.
That's right.
And so people get all worked up, and we have clients now who, like, they're probably still years away from actually taking it. I think it was very smart of them to go ahead and actively hire us. But the reality is that we're not. They haven't actually taken their property yet. They haven't even funded the project yet at some level. Yeah. So you're going to have a decision based on public use that a project's necessary. You're going to have some development research, understanding of how this property actually practically looks. So it's one thing to say we need to widen the road in Iredell County. It's another thing to actually go in and say we need to widen the road this much in this location in this spot. And there's not a map act genie who snaps their finger and all of a sudden we know. So that takes time. And then they have to figure out what they're going to do with the money. So then they finally fund it. Usually when people get involved with us is when they are contacted by a right-of-way agent, or a lot of times their neighbors contacted by the right-of-way agent. So we're going to have a project development. We're going to have a project identification and approval. We're going to have development of that project in terms of practically what it's going to look like. Then we're going to have funding, and then finally, sometimes 4, 5, 6, 7 years down the road, sometimes more, sometimes less, they're actually going to step in and start to proceed with acquiring properties.
That's right.
So let's start there. Okay. So we're back to our road project, and they decided, in 2014 they were going to widen the road, and in 2023 they gave them the funds, and now here we are in 2020, 2025, and they've actually started taking part of the project. So what does it look like from there?
Right. So one thing that's good for the homeowner to remember is just because they identified the project or the need for it in 2014 doesn't mean your property will be valued with 2014 property values. Okay. Right. That's a very important thing to note.
Okay.
But with that being said, they're going to start sending what we call a right-of-way agent to your house. Okay. And we'll send them to your house. They will come to your house and knock on your door. And they will present you with documents, or they'll mail you documents. And those documents will have an offer letter. Usually they'll do an offer letter. There'll be a letter in there explaining the project, give the project identification number. Because sometimes some of these projects we call them STIP numbers. Basically just a number the DOT uses to identify the project and what it's for. And with that being said, they'll give you this letter and let you know what they're getting ready to do. And usually, and what they should do, is give you a document that it's a map showing your property, and will have lots of pretty colors on it, and it will show you exactly what they're going to do to your property. Okay.
So let's back up a second. All right. Because, let's talk about right-of-way agents.
Yes.
Because we talk about there being different people involved in the process in different parts, pre-litigation, litigation. Pre-litigation, the central figure typically a property owner is going to deal with is not their congressman who decided to widen the road, or not the other legislatures that decided to pay for it. They're going to be dealing with Joe Right Away. We're going to call him Joe Right Away. And Joe Right Away is who? Who is this guy? Where does he get all this authority? What is he not? What's his role in this in the pre-litigation phase?
So the various states of the union have decided that it is better to hire private companies to assist the state with right-of-way. And so Joe Right-of-Way is not a actual government employee. He's a independent contractor hired by the government who works probably for a larger company.
He could be Joe Lean.
He could be Joe Lean.
It could be
Joe
he or
Lean
she.
or
We're not
Joe.
just, yeah, and we don't want to discriminate here on the.
And it is it's about 50-50, honestly.
Okay.
It's Joe Lean and Joe 50-50.
All right.
So we see these folks, they come to your house, and what they're not attorneys. They're not surveyors. They're not appraisers. They're sometimes, once in a blue moon, they'll be a real estate agent. They'll have a real estate license, but they're not somebody with a degree or certification specifically for this job. But what they're going to do is approach you about and pressuring you into selling part of your property to the government without having to file condemnation or getting what I would say a fair sale.
Yeah. Now, got to be fair. Right away, just like everybody else.
Sure.
There's good ones. There's bad ones.
Yeah.
They're doing their competent ones. There's incompetent ones. They're across the spectrum.
That's right.
But I just want to make sure people understand a right-of-way agent is not a lawyer. So they know a little bit about the law, but they don't understand the full import of the things they're doing from a legal standpoint, like an attorney would. They're not an appraiser. We're going to talk about, we got a whole episode. We're going to talk about appraisers coming up. And so they don't fully understand all of the rules that relate to appraisers and all of the regulations and things that go to that. They're not surveyors.
No.
They're not actually governed. They're not elected.
No, sir.
No one elected them to come be the person that negotiates. Yet here we are in this situation where your property is now being taken, and the person you're going to deal with is not an appraiser, is not a lawyer, is not a surveyor, and they have a tremendous amount of authority.
Yes,
They have been given, they have very wide latitude to be able to settle cases correctly. Correct, right?
Yeah, so they're given a latitude. In other words, the state gives them a number amount what they're allowed to settle for. And so generally, it depends on the property, obviously, because that's going to dictate how much money we're going to start out with. But they're going to be given what we call sort of a negotiation power, sort of kind of like a power of attorney on behalf of the government to settle these cases.
Right.
Yeah.
And they often do their own town halls. So like they'll actually organize a public meeting. So there might have been a public hearing when they decided to do this project in 2014. And then you finally saw in the news that it was funded. And then you saw some stakes in your yard, and you started seeing the sort of all of the markers that this was going to happen. And then sometimes they'll say, hey, we're going to get together, and they'll do a town hall, or not always, but a lot of times they'll do a town hall and say, hey, we want you to know this is what's going on, and this is how the process works. And, we're going to make you an offer, and you can take it and it's almost like, this is so crazy. I never thought about this. So like, you never you're a terrible driver. You've had a bunch of speed tests.
I have.
So, and I've been known to speed a little bit, but it's like when the cop pulls you over and they say, you don't have to go to court. You can just pay off it's the same thing, isn't it? It's exactly, they're doing the same.
Right.
So they'll pull you over and say, well, Mr. Brown, you don't, some of my ticks, I had to go to court, but they'd say, you don't have to go to court. You can just pay this off, which may or may not be good advice. It's true. You can just pay it off, but that doesn't mean that's what's in your best interest. That's kind of what you get with right-of-way agents, right? They'll say, you can take this settlement, and can you take it?
You can.
Yeah, for sure.
It's kind of interesting because, conceivably, as the police officer, the state trooper, whoever it is, or the right-of-way agent, are they providing legal advice? Is that the unauthorized practice of the law? Anyways, I don't know. But with that being said, it's interesting how they'll have these town halls. And a lot of times, having been to some of these, or a lot of these, what we have is, and we've conducted our own town halls.
Yeah, sure.
We've conducted our own town halls and have had great success with those. But having been to them, they'll have the engineers for the project there, but they won't have any type of general counsel. They won't have surveyors there, just the engineers. And engineers in a town hall can be very interesting because you have to imagine with us here that, you know, we're dealing with math nerds.
That's not fair.
No, that's not fair. I have a lot of friends who are engineers. All my friends are undergraduates.
You did have friends that are engineers.
Yeah, I did.
You don't
I
have
still do.
consider engineers.
I love you all.
That's called all nerds.
I love you all. So, so we, you know, they're trying to field these really difficult. A lot of these owners, some of them will come and they'll have very difficult questions in these town halls, and then usually they just end in this like kerfuffle of, you know, dissatisfied answers, and they go away frustrated more than they were when they came.
Yeah, I mean, I think the thing that people need to take away though is in the pre-litigation phase, the right-of-way agent is not independent. They're not a neutral party. Absolutely, they are working on behalf of the state to resolve the acquisition of properties that have been approved and funded so that these projects can move forward, ideally without litigation. Now, don't get me wrong. We are huge proponents of settling cases pre-litigation.
Sure.
I mean, that makes perfect sense. But understand the right-of-way agent is going to step in there, and they're not your friend.
No, they're not your friend because they want to get hired again. You don't believe they want to get hired again?
No, I don't believe that they would affect their decision making by picking to go first, so then they could be hired. Okay,
absolutely not.
All right, very good. Appraisers are involved too. They get appraisals. The right-of-way agent orders the initial appraisal.
That's right. They will order the initial appraisal.
And we're going to talk about appraisal. But the appraisal will actually establish the value of your property both before and after the taking, which provides the foundation for what just compensation.
That's true.
Okay. Thank you so much for watching another episode of Stolen. We need you to subscribe. We need you to subscribe and watch our show. We're going to try to be more serious in future episodes because these really are these really serious topics.
Very serious.
These serious topics. But at the same time, thanks for being on. That's right. Subscribe. We'll see you next time. Thanks a lot. Thanks, folks.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.